Question is that the bill be now read a second time. Mr. Souza.
Mr. Speaker, sir, I support this bill because it strengthens our border enforcement of IP rights and honours our international obligations. IP rights are important. They promote creativity, innovation. The four statutory IP rights regimes which this bill seeks to amend relate to copyright, registered design, geographical indicators, and trademarks. At this point, I should declare that I am a practicing lawyer whose practice includes IP law. IP rights allows branding and quality assurance through exclusive access to goodwill of products from a particular brand or a place of origin. They also allow creators to support themselves through their creations by recognizing and protecting the property within their creations. In fact, the Copyright Gramophone Records and Government Broadcasting Act of 1968 was enacted to, and I quote, deal with the increase in the importation and sale of pirated records of copyrighted musical works, unquote, which threatened the livelihood of local artists, composers, and musicians. Therefore, protecting IP rights prevents theft, not of tangible goods per se, but of an intangible good. The protection of IP provides an incentive for and rewards creativity and innovation, extending even to software creation. By promoting innovation in art, society benefits through the protection of IP rights. How this bill strengthens the enforcement of IP rights is through the framework of detention, further supported by easier access to information. Detention is important because the protection of intangible IP rights rests in the tangible goods which bear the IP right. This bill expands the scope of the power to detain to include not just the import, but also the export of copies of alleged infringing goods. Additionally, detention can be initiated by the IP right holder and not just a state official. However, the consequences of a wrongful detention of allegedly infringed goods can be very costly and disruptive to the importer and exporter. To prevent abuse, a balance has been struck by getting the requester to pay compensation for loss or damage as a result of the seizure if the requester requests to detain the suspected infringing goods but did not institute any infringement action in the end. While the test is not new, example Section 140 big I, capital A, of the current Copyright Act, I would ask how effective has this test been in striking the balance between swift and effective action and deterring potential misuse of power. I would also like to seek more clarity on the difference between what the Director General can prescribe and what the Minister can make rules on. This is in relation to the notice to request for detention of suspected infringing goods. The Director General is to determine the form of the notice, which is supported by such documents and information as the Director General may require. Yet, the Minister is to make rules for the manner in which notices are to be given and for the giving of information and evidence to the Director General. Additionally, the explanatory statement says that Clause 35 enables forms of notices, and I quote, to be determined by the Director General instead of being prescribed in the rules, unquote. Because of the distinction drawn by the High Court in Cheong Seok Leng, the case of that Cheong Seok Leng, between actions that have a legislative effect and those that are executive or administrative, rule prescription and executive decisions do not seem interchangeable. Therefore, I would like to seek clarification from the good SMS, the respective roles of the Minister and Director General in this area. This power to detain is supported by making it easier for the authorities and the IP right holder to get certain information. And the phrase, I quote, any information or document that the officer considers relevant for statistical or research purposes, unquote, is quite broad. I would like to seek, therefore, clarification on what sort of document, information, research, or statistic is envisioned behind the grounds to get such information. This broad access to information is augmented by preserving the privilege against self-incrimination. I'm referring to the new section 140, capital E, capital A, subsection 5 of the Copyright Act, as inserted by Clause 4 and other similar clauses. I have two questions regarding this. One, would a bare assertion that the information would impose a person to criminal liability be sufficient to trigger this provision? And two, the provision says that the document or information is not admissible in evidence against the person in criminal proceedings except under some circumstances, for example, where false information was provided. But, for example, in a normal criminal trial, if the accused chooses to give evidence, he would generally need to answer any question or risk having an adverse inference drawn against him. Therefore, to what extent is this provision meant to operate? This bill, which implements our obligations under the EU-US FTA, or the European Union-Singapore Free Trade Agreement, will be implemented in phases as indicated in the press release and reflected in the bill. According to the press release, this is in accordance with Singapore's EU-US FTA's obligations and customs operational needs. Therefore, I would like to ask, what is being done to ensure that we have sufficient operational resources such that the relevant officers will have the necessary knowledge or expertise to be able to discern what information is necessary, quote, to enable any action to be taken in relation to future shipments of goods, unquote, and whether information sought is indeed necessary to institute infringement action. This bill also seeks to rationalize border enforcement procedure across the four statutory regimes under the Copyright Act, the Trademarks Act, the Registered Design Act, and the Geographical Indicators Act of 2014. In relation to this, why is it that the distinction between goods in transit that are consigned and those that are not consigned is not drawn for the Geographical Indicators Act and Registered Designs Act at clauses 47 and 53, but are drawn for Copyright Act and the Trademarks Act at clauses 7, 25, 60, and 78. Because costs involved in export and imports have tended to decrease and exported and imported goods have become more widely available, this bill plays an important role in enhancing our border enforcement of intellectual property. Besides enhancing our border enforcement of IP rights, this bill helps us honor our obligations under the EU-US FTA. Furthermore, international agreements are particularly important in IP law because of the principle of territoriality, which states, and I quote, IP rights granted and recognized in one country are protected within the territory of that country only. In an increasingly interconnected world and globalized market, the importance of international agreements is heightened further. Therefore, Mr. Speaker, because of these two broad reasons, first, that this bill honors our international obligations, and second, that it strengthens the enforcement of IP rights across our border, I support the bill.